Legal dictation with 70 to 80 words per minute. Get ready. 3 seconds. 2 seconds. Start. These 4 appeals by the special leave are directed against a common judgment of the Assam and Nagaland High Court acquitting the respondent of the offence under section 302 of League 149 of the IPC and will be disposed of by a common judgment. The 4 respondents in these appeals were convicted of the offence under the above section by the Additional Session Judge Gauhati, in whose court they were tried jointly along with Narendra Basmotari. The victim of the offence was one Moniram Kotwal. Narendra Basmotari's conviction under section 302 of the IPC was upheld by the High Court, but there being no appeal on his behalf against that order, these appeals, we are not concerned with this conviction. The prosecution story may not be briefly stated. On May 20, 1962, at about 10 or 11 a.m., the deceased Moniram alias Dhan Bahadur and some other Nepali persons were grazing their cattle in Agarkata Government Grazing Reserve, which is described by PW2, the informant, as Koirani Reserve. The 4 respondents with Narendra Basmotari, armed with deadly weapons like bows, arrows, and lathis, tried to take the grazing cattle for impounding them on the plea that these cattle had strayed into their thatched field in the reserve. On protest being raised by the grazers, the accused person assaulted them, and Narendra Basmotari, whose cattle is not before us, younger son of accused Bharga Devani, respondent in CRA number 76 of 1967, shot an arrow at Maniram and killed him. There were about 16 or 17 Kacharis present at the place of occurrence on the side of the accused person. Angres, respondent of CRA 77 of 1967, is alleged to have hit PW2 on his head with a lathi. Barga Diwani. It is the prosecution case instigated the accused persons to assault the grazers. Suren and Nibaran, another son of Barga Diwani, respondent in CRS number 78 and 79 of 1967 respectively, were also alleged to have shot arrows at the cow herds. The trial court convicted them all under section 302/149 of the IPC and sentenced them to imprisonment for life. That court observed that though Barga Devani is an old man and has himself not armed, he was nevertheless the leader of the accused and should have known the offence likely to be committed, the unlawful assembly. On 5 appeals having been preferred to the High Court, that court in a somewhat sketchy common judgment allowed the appeals of the 4 respondents and dismissed that of Narendra Basmotari. The High Court took the view that There was nothing on the record to show that the common object of the assembly was to cause death or to commit murder. It further held the charge framed by the trial court to be defective and observed that a charge under Section 147 or Section 149 of the IPC should also have been framed against the accused person.